Welcome, and thank you for standing by. At this time, all participants are in a listen-only mode. During the question and answer session, please press star 1 on your touch-tone phone. Today's conference is being recorded. If you have any objections, you may disconnect at this time. Now I will turn the meeting over to Ms. Janice Wingo, International Trade Administration, U.S. Department of Commerce. You may begin.
Thank you. Good morning, and welcome to this morning's webinar. Today, our webinar series is going to be a little different in that it's going to be just a 30-minute webinar, and we're very lucky to have with us a lawyer in Beijing. So good evening to Lawyer He, who's in Beijing, who's going to speak to us today about how to deal with .cn domain name disputes in China. Lawyer He is going to speak to us for about 15 minutes, and then he's going to take questions and answers for about 5 to 10 minutes. Afterwards, there's a second webinar on a different website, and that will begin at 10:30. We'll listen to Lawyer He speak to us there. But let me tell you a little bit about He Jing. He Jing has his bachelor's degree in physics from Peking University. He also has his Juris Doctorate degree from Notre Dame here in the United States. He spent many years with a very large American law firm in both Hong Kong and Beijing, and now he is a senior consultant with Ziwei Partners in Beijing. He specializes in all matters of IP, and as you can tell, he's bilingual. So, He, please tell our listeners how to deal with .cn domain name disputes in China.
Thank you, Janice. Thank you for the introduction. So today I just want to take this opportunity to talk to you about and how to deal with .cn domain name disputes. And firstly, I want to go through some of the basic facts about what's going on in China in terms of the Chinese domain names. Then I will give you some examples. What's more important is probably just to give you some knowledge about what are differences in terms of legal approaches to dealing with some domain name disputes, particularly, what's the difference what's the difference between dealing with disputes through arbitration or litigations if you want to take your domain name back. And I will talk a little bit more in terms of the legal test, how the Chinese court or how the arbitration panel deal with some of the key issues in this part. And lastly, I will show you, offer some practical insights into this area. Next part, I just want to touch on some very basic information about what's going on the ground. In terms of .cn domain names, you probably already know that there are basically 4 forms of the domain name: the .cn, .com, .cn, .net.cn, .org.cn. And normally the .cn ones probably the more popular ones. A total of, right now in China, there are about 7 million .cn domain names, including all the 4 forms of the domain names. That's the data by the middle of 2010. Right now, every year, there are about hundreds of domain name disputes in relation to Chinese domain names. Now, it used to be true that cyber squatters, who take away other people's domain name, which are identical to legitimate brand owners, they normally do this for money. Okay, they register the names and they're trying to find a way to sell it for money. One of the sort of famous examples is Google.cn. This actually happened in 2005. There were reports that Google really spent quite a big amount of money to buy the domain name back from the cyber squatters. Now, there's a latest trend which I just want to take notes here in this presentation. The next slide is actually, if you look at it, look at the picture, just look at on the upper left corner of the web page, you will see the Groupon.cn. Okay, but this Groupon.cn is not a Groupon that you're familiar with in the U.S. This is actually a website that a Chinese social shopping site set up. Okay, they managed to register this domain name earlier than anybody else, and they actually are very well-financed, well-funded social shopping company. There were reports that they spent millions and millions of dollars, U.S. dollars, okay, spend a big fund in China to do the promotions, to promote the site. Looks like the business is really on the good side, okay? And they also report Groupon from the U.S. trying to do a business deal or trying to buy the domain name from this Groupon.cn, but reportedly, this Chinese Groupon.cn rejected the offer. So if you look at the next one, this is the domain name called gaopeng.com. This is actually the Groupon U.S., the Chinese operation. Groupon just opened its China operation, I think a few days ago, but they have to do that through this domain name called Gaopeng, and they have to say it's powered by Groupon. Now, what does this mean? This is one of the signs that the Chinese site squatters, they're not really the old-time site squatters anymore. They actually they take domain name, sometimes not just for sell it for some small money or some quick money. When they really see that the domain name is good, actually represent a good business model, they could learn it quickly, and actually sometimes they got a good good finance, good support. They actually launch a business under the same domain name. I think that's probably one of the trends that brand owners should be really fully aware of. It's not surprising that the people should be really taking note, especially they have the global business model. They really should consider the Chinese, the .cn domain names at the early stage of their business. The next slide, I want to talk a little bit, I want to just give you an overview about what are the real approaches, what are the typical approaches, legal approaches that you can go through to take, to fight over the Chinese domain names. There are typically two ways, in China. There are two major approaches that you can think about if you have some domain name dispute. First one is arbitration. This is sort of an official arbitration channel. In China, all the Chinese domain names are regulated by this quasi-government authority, CNIC. And the CNIC designates the CTAC, we call CTAC, CIETAC. That's like American Arbitration Center. This is the largest official, the Chinese arbitration center. So this arbitration center is in charge of all domain name related arbitration cases. So any applicant who registered Chinese domain name .cn or .com.cn domain name, they are contractually obligated to go through arbitration to deal with the dispute. So they must respond to any request for arbitration. Okay? So this is one of the typical way you need to go through. And if you want more information, you can see I put the web link here. You can get a very clear, detailed procedure information through that website in the CTAG. But I will talk a little bit more about the legal test with the arbitration later. Another typical way is doing litigations. At a Chinese court, you don't really need to wait to do arbitration. You can just put the other side on the court directly and to litigate and ask to get back the domain name. Now, what are the differences between the arbitration and the litigations? I put a chart, the next slide, I put a chart over here so you can see some of the differences. If you really look into it, one thing maybe stands out is that the arbitration probably offer a much faster approach. Officially, the rule is that the arbitration panel have to conclude a case within 60 days. But if you go to litigation, it can really go, easily go take 9 to 12 months. Okay, this is simply the court of first instance. And another advantage for arbitration is that the evidence is relatively flexible and no special requirements. One of the big pains for our clients to litigate in China is that they have to notarize and legalize all the evidence that come from the overseas, which means that you have to send all the documents to the Chinese embassy or consulate office in the U.S. to legalize them. But for arbitration, you don't need that. And another interesting to note is that the expert panel normally has quite a wide power of discretion, and actually our experience has been quite a positive because the expert relatively progressive, and when they see there's some bad face in the related to the domain name, they normally give a lot of sympathy to the legitimate brand owners. This is one of the reasons we normally would ask our client to consider the arbitration in terms versus litigation. But there's one thing you have to keep in mind: arbitration decision is not going to be final in terms of when it comes to the domain name if the other side wants to go through the judicial appeal. In another word, all the arbitration decisions are subject to judicial review in China. So if you are predicting there are going to be a big fight, actually, if the other side is really keen to keep this domain name and they're going to have a lot of resources to fight, probably go through the arbitration would not really give you that much advantage, which means that you will go through litigation anyway. So in that circumstances, you might just have to go to litigation and go to the court and get a final result probably sooner than going through the arbitration first. So I just want to make a note on this point. So this arbitration, this is the difference between arbitration and litigation. The next slide, I want to talk a little bit about the legal test. This is maybe, we have to use a little bit of legalese, but it's quite relatively straightforward, actually. If you look at the rules in China in terms of domain names, how to deal with domain names, the rules are relatively close or very consistent with the international practice. And so to prevail in a domain name case, for plaintiff, if you're a legitimate plan owner, if you think, hey, someone use a mark that is identical or similar to my mark in a Chinese domain name, you basically, that's the first point you need to show, and they also need to show that, hey, you do have a good civil interest to that mark. Maybe you have a trademark, maybe you have done have lots of business under this mark or identical domain name outside of China. For example, if you have got this the same domain name outside China, for example, .com for many years, you've done lots of business, that could be acknowledged as a legitimate civil interest that you can have. Okay. The second thing, for the plaintiff point of view, that you have to prove is that the other side does not have a legitimate interest over the domain name. And said another way, the other side has no trademark, has not registered, has not really used the domain name for any other purposes. They have no legitimate interest. And the third test is that you need to show that they have some bad faith. They have the bad faith in registering or using the domain name. The bad faith normally is quite a critical point in the domain name case. So what kind of evidence you need to think about or you need to take into account when you are running toward domain name disputes? The next slides, I have listed out some of typical examples of what is counted as a bad faith. In the Chinese arbitration panel or the Chinese court, okay, it's very similar. These tests are very similar in terms of what is counted as a bad faith. The arbitrators or the judges look at the several things. First thing is the purpose. Okay, if you have some evidence to say the other side, the cyber squatters, it really register or uses the domain name to sell, actually to lease or assign this domain name to others or to the brand owner itself or other competitors' profits, and that's a very strong evidence. Many times that you will see the cyber squatters put up put a sign or put a sentence or statement on the web page to say, hey, this is domain name is up for sale. Okay, this actually will be good evidence for brand owner, for plaintiff point of view. The second kind of typical evidence is that the same person, the same defendant, repeatedly register other people's domain names to stop legitimate people from using the same domain names. And very often, actually, cyber squatters will not only just take away one domain name of others. They will do this kind of. Normally they have registered a number of domain names which contain a mark which are identical or similar to other people's trademarks. So when you do the search and find out what kind of thing this person has done before in terms of cyber squatting, that will be very good evidence. And the third thing that the third kind of proof is that anything that you can show that the other side's activities have damaged reputation or interfere your business operations or mislead the public. Okay, so you will see whether you can find this kind of evidence. And maybe depending on the circumstance of each case, there may be some other good evidence that you could find to support your case. Now, the last part, we're coming to the last slide. I just want to sort of recap what I just said, or and also offer you some of our insight from our practical experience. Normally, as I said before, we would normally recommend our client to consider arbitration because it's really fast and expert, relatively knowledgeable and progressive in this kind of cases. So it's relatively reliable. And the second thing is that we actually recommend our client really actively thinking to using arbitration or even court litigations to pursue the domain name cases instead of just waiting or simply relying on the cease and desist letter. Most of the time, the other side will not really respond to a cease and desist letter. Okay, but it's very interesting. Very often we find out in domain name cases when you really file an arbitration case, and the cyber squatter, if the other side is really cyber squatters, they may not really show up and spend the legal fees to deal with the arbitration. If they do, it's not going to be professional work. They just make some arguments which not really convincing at all. There's no kind of evidence, and very often they actually will just simply absent from the proceeding. And when they do that, the absence to respond the complaints will be actually one of the good evidence to show the other side has a bad faith in registering the domain names. So you should be actively thinking actually at least to initiate a case. When the other side do not respond, you probably can get a good victory very quickly. And another thing is that we find out even if the cyber squatters trying to fight over the domain name through the arbitration, but when they lose it, they don't really want to appeal anymore because they know most of the time the court will actually support the decision made by the arbitration panel, and so they don't really want to bother to spend the fees to go through the whole litigation, to go through the appeal. And again, this just means that you may be able to just get a victory right after the end of arbitration. So this is what I want to say for now, just to give you a brief framework and how things work in terms of arbitration and the court litigation in order to get back your domain name.
Thanks, Ho. Operator, can you tell people how they can ask a question?
We will now begin the question and answer session. If you would like to ask a question, please press star 1. You will be prompted to record your name. To withdraw your request, press star 2. Once again, to ask a question, please press star 1. Erica Finkelson, you may ask your question. Please check your mute button. Your line is open.
Hello. I was just wondering if you could describe whether or not the legal test for arbitration is the same as litigation. Thank you.
Sure. It's actually very, very close. Okay, it's almost identical. There are just a very slight difference. Okay, it's a very slight difference. And in litigations, there's one of the rules. It provides that if you register someone's well-known trademark as domain name for commercial purpose, and that's using our American legal terms, that's like a bad faith per se. That's just a bad faith per se. Mm-hmm. But in terms of arbitration, because for the arbitration panel do not have a power to recognize what is the well-known trademark or not. You probably know that well-known trademark, this kind of recognition is quite a big deal in China, okay? And it takes a lot of evidence to make this kind of recognition or determination. But arbitration panel do not have the power to do that, so they don't really the rules do not provide a very specific rule for well-known trademark.
Thank you.
At this time, we have no further questions.
Lawyer Hub, this is Janice. For people who will be listening on the recording of this presentation, would you be willing to take questions, email questions?
Sure. Yeah, I'm more than happy to take questions by email.
Could you tell us what your email address is, so if people have a question later on, they can write to you in the email, and since you are the expert in this area.
Thank you. My email address is zyng.he@zypartners.com. zypartners.com.
Well, if there are no other questions, we're going to close this webinar down, and we're going to have another, there's another webinar that Lawyer Huh is going to get. This one is actually on rectifying enterprise names. It has a different dial-in and a different download for the web. So you'll need to exit this web page and enter to another web page. But thank you again, and we look forward to speaking with you at 10:30 with Lawyer Huh on rectifying enterprise names.
Thank you, everyone.
This concludes today's conference call. Thank you for participating. You may disconnect at this time.